Welcome back to The Loud Little Ducky. Today's video is Omar's opposition for Gingras to intervene. Gingras is trying to make this an intervention, but he is the one that needs some intervention to his life. But let's see what Omar has to say. So we have Omar Serrato, aka Tilted Lawyer, attorney for respondent Michael Maricini, filed on October 1st, 2025 in the Superior Court of the State of California, County of San Francisco, in the Owens v. Maricini matter. Opposition. David Gingras' motion to intervene, strike, sanctions, and motion for disciplinary referral to the State Bar. So, Gingras put in all that. We recently went over that. Now, Omar is like, wait a damn minute, because you left some shit out, David. So, introduction. On August 25th, 2025, respondent moved to disqualify attorney David S. Gingras from representing petitioner. The motion focused on Gingras' conflict of interest, both in defending his past conduct and due to the advocate witness rule, a legal principle that prohibits an attorney from acting as both an advocate and a necessary witness in the same proceeding. Respondent argued Gingras needed to defend himself in a pending state bar investigation involving respondent, and his role as a witness to key disputed events made him unfit to continue as counsel. On September 12, 2025, Gingras, not a party to this case, responded with a wide array of counter-motions, calling himself an intervener. He seeks 1. Leave to intervene in this family law action for limited purposes of pursuing sanctions against a respondent's counsel. Stay mad, Gingras, because this is not the correct way to go about it, in my opinion. An order striking the motion to disqualify in its entirety. 3. Monetary sanctions against respondent's counsel under Code of Civil Procedure 128.5 based on allegations that the disqualification motion was frivolous and filed in bad faith, which it wasn't, because there is a conflict. It'd be one thing if he was just making a whole bunch of shit up and there truly wasn't a conflict, but he just didn't want you on this case. But that is not the scenario. I mean, he doesn't like you, but there's also a reason you should not be on this case representing Owens. So it is not frivolous and it is not in bad faith. A disciplinary referral of respondents' counsels to the State Bar of California premised on the same accusation of misconduct. Gingras' filings attempt to interject issues about opposing counsel conduct into a DVRO process, referencing matters outside the court's purview, such as YouTube commentary and social media. Yeah, which have nothing to do with what is happening in court or the things that Laura is alleging Maricini did, even though I believe she is a liar, and especially trying to renew on him testifying with going to testify on a valid subpoena. Because the filings could disrupt the DVRO schedule and impede respondents' trial preparation, prompt resolution is necessary. Accordingly, respondent brings the present request for order shortening time. And we know that there's supposed to be an emergency hearing today, I guess to go over this and the disqualification, because this is some nonsense being brought in. Because what this is supposed to truly be about is Owens in fear for her life from Maricini, and does she have a valid reason to fear for her life? Did Maricini break laws, violate restraining orders, and all that, even though there has been no violations found thus far. Um, that is what this is about. And if it is supposed to be about protecting Owens and her fear, you would think that as somebody that's supposedly looking out for Laura's best interest, that it would be about getting her the protection she needs. But it's not about that. That's why it really doesn't matter how long this DVRO case goes on to them, because it's not about actual fear. It's about jabbing and trying to get a win that frankly they don't deserve and should not be legally found. Ensuring Gingras' motions are resolved before the DVRO renewal trial process or proceeds, the transaction clarifies that the direct link between disruptions described above and the action now sought. Procedural history. The case concerns domestic violence restraining order between the petitioner Owens and Maricini. It was filed in 2018. She ended up with a temporary one in January of 2018 that both parties agreed to extend without admitting wrongdoing until July 10th, 2020. Then in 2020, over respondents' objection and without finding new abuse, the court renewed the DVRO for 5 years, effective through July 10th, 2025. July 10th, Owens sought a second DVR renewal with the intention of making it permanent. Maricini maintains the claims that Owens says are fabricated, vigorously contested the renewal, and has requested a multi-day evidentiary hearing. David Gingras is an Arizona attorney specializing in internet defamation. I don't I don't think he specializes in it. And if he does, why is he not applying logic to anything he's been doing on the internet in the last year and a half? He became involved in the Owens v. Maricini dispute prior to the latest renewal in June 2024. He represented Owens in an Arizona trial, Owens v. Eckerd, and objected to Maricini's role as a subpoenaed witness. Maricini was lawfully subpoenaed to testify in the Arizona case. Despite this, Gingras tried to invoke the California DVRO to block Maricini's testimony, as stated in Gingras' declaration. He contacted law enforcement on June 10, 2024 to have Maricini arrested for attending the court proceeding. Law enforcement denied Gingras' request, finding no violation. This led to a state bar complaint against Gingras. The resulting in investigation found probable cause and is proceeding to disciplinary action. See Exhibit A, correspondence from Arizona State Bar. We've looked at that in other filings recently. A hearing on Owens' renewal took place on August 15th, 2025. Gingras, representing Owens, proposed a short hearing while Maricini requested a long cause trial. Maricini's request was granted. Following the August 15th, 2025 hearing, attorneys Omar Serrato and Rachel Juarez, defending Maricini, held a conference call to discuss the case, meant to last 5 minutes. The call lasted over an hour, focusing mostly on Gingras' personal vendettas, impending Arizona State Bar disciplinary, and DUI arrests. His DUI arrests have nothing to do with Owens' representation or about this case. That is his own personal matter. That has nothing to do with Rachel or Omar or Maricini. Gingras spoke rapidly and struggled to focus. He said he needed Maricini to testify to support his Arizona State Bar defense. I then told him this was a conflict of interest as it brought his personal concerns into the case. Yeah, you don't get to use a case for your benefit and try to twist it to something that benefits you, because that benefit may not benefit Owens. Based on that discussion, I filed a motion to disqualify due to an obvious Rule 1.7 conflict affecting these proceedings. I prepared the motion and told Gingras I would e-serve the documents. Gingras then said he would not continue to representing Owens and sent written confirmation. As trial neared and ethic concerns persisted, counsel filed for Gingras' disqualification on August 25, 2025 to prevent delay, questioning whether he would voluntarily withdraw. The motion was expected to be unopposed and aimed at removing distractions before trial. Yeah, if you're not going to be on this case, who gives a shit? The disqualification motion cited two ethical grounds: advocate witness rule, because he's a witness on key facts, would face a conflict if he continued advocating in the case, and this could prejudice the trial. And two, Gingras' personal conflict due to the pending disciplinary case, which creates self-interest that might influence his conduct in the proceedings. The motion noted Gingras intended to withdraw and stated it was likely unopposed by Owens, seeking to formalize his exit and protect proceedings from further distractions. Gingras can still attempt to re-enter this case. Exactly. And we don't take your word. Rather than withdrawing, Gingras responded to the disqualification motion by filing a motion to intervene, strike sanctions, and disciplinary referral against Serrato. Gingras accuses Omar of court fraud and gross misconduct. He claims, I misled the court about Gingras' being Owens' counsel. The disqualification motion was frivolous and filed in bad faith and intended to harass him, and that I'm using court filings to run a social media campaign to smear him and build my YouTube presence. Gingras asks the court to impose monetary sanctions and attorney's fees on Omar under CCP 128.5, strike the motion to disqualify, declare violations of multiple rules of professional conduct, and refer Omar to the state bar. Granting these demands would punish and potentially silence Omar. Gingras' filing featured heated rhetoric and personal attacks, for example, accusing Serrato of arrogantly and menacingly boasting about violence, calling his YouTube work sleazy, and describing the disqualification motion as a scheme to defame Gingras online. We don't have to defame you. You make yourself look bad. Okay. Points of authorities. David Gingras has no standing to intervene in this case. Legal standard for intervention is under California Code of Civil Procedure 387, permissive intervention, a procedural device allowing a non-party to join an ongoing litigation with the court's discretion. Is appropriate only when non-party demonstrates a direct and immediate interest in the action. A direct and immediate interest means non-party will gain or lose legal rights based on the outcome of the judgment itself. Toretti versus Lift. In contrast, if the impact on the non-party is merely indirect or consequential, intervention is not permitted under this standard. So an example of somebody motioning to intervene, if any of you watched the Depp v. Heard trial, when the TMZ guy came in and was going to be a witness in the case, and Heard's team was people were trying to supposedly get him to reveal source information, and different things. Well, because this person used to work for TMZ, and that is why he was a witness and the one who got the tip, TMZ intervened in a limited purpose just on that particular witness's testimony, trying to limit things that he could say, or maybe just get it to where he can't testify, because TMZ does not want sources and things to be disclosed. There's also a NDA that people sign when they're with TMZ. So this employee would supposedly be violating an NDA. And it affects journalists and people because if sources get exposed, then there's going to be less sources out there because they're going to be afraid of what happens if they ever get revealed. And it's supposed to be kept quiet. So that is an example of somebody that was intervening for a limited purpose where they were like, okay, we'll hear you, but nah, we don't really care because you're not a party to this case. That's a lot of times people can intervene. It doesn't necessarily mean anything's going to come of it. But anywho, all right. The permissive intervention statute balances the interest of others who will be affected by the judgment against the interest of the original parties in pursuing their litigation without being burdened by others. City and County of San Francisco versus State of California. If proper procedures are followed, the court has discretion to permit a non-party to intervene in a litigation pending between others, provided that the non-party has a direct and immediate interest in the litigation. The intervention will not enlarge the issues in the case, and the reasons for intervention outweigh any opposition by existing parties. B. Gingras lacks direct and immediate interest in the DVRO proceedings. Gingras seeks intervention in a domestic violence restraining order renewal case between Owens and Maricini. The underlying dispute concerns whether Owens should receive permanent restraining order against Maricini. Gingras has no direct interest in the merits of the restraining order request, as that dispute is strictly between the actual parties. Right. Gingras stated interest relates entirely to his personal reputation and desire to avoid sanctions which are collateral to subject matter of litigation. His motion seeks relief solely against opposing counsel Omar, including monetary sanctions, striking of motions, and disciplinary referral. These personal grievances against an attorney do not constitute this type of direct and immediate interest, meaning a stake in the outcome of the case itself. That's California law requires for intervention. Yeah. Gingras' beef right now is with Omar. That's it. While the restraining order is granted or denied, will have no effect or direct legal operation or on Gingras, as he is neither a petitioner seeking protection nor the respondent from whom protection is sought. Any impact on his reputation or professional standing would be indirect and speculative, which is insufficient to support intervention. C. Attorneys cannot intervene to pursue personal relief in client action. Yeah, he needs to take that up somewhere else. If he thinks Omar is doing something, then he needs to take that up with the proper authorities. This is not the time. California courts have specifically addressed the improper use of intervention by attorneys seeking personal relief in their clients' cases. Because an attorney is very unlikely to meet the criteria to intervene and become a party to the underlying action, the fundamental rule is that the attorney is a non-party to the client's action and cannot appear on his or her own behalf to seek any relief in that action, including enforcement of contractual lien against the proceeds of the judgment. The limitation is found on the fundamental principle that one who is not a party to a proceeding may not make a motion therein. Southern California Gas Co. versus Flannery. After the client obtains a judgment, the attorney must bring a separate independent action against the client to establish the existence of the lien, to determine the amount of the lien, and to enforce it. This principle applies equally to Gingras' situation. If he believes he has been wronged by opposing counsel's conduct, the appropriate remedy is through separate proceedings, not an intervention in the underlying case. The law requires a specific present interest in the subject matter of the action, rather than merely a collateral interest in the proceedings. Contentions of falsehoods that are demonstrably false do not qualify. So even if what Gingras was saying, this is still not the, even if what Gingras was saying is true, which we know it's not, this would still not be the appropriate way to go about this with his grievances on Omar. D. Gingras' intervention would improperly enlarge the issues. Gingras seeks to intervene solely for limited purposes of seeking sanctions against Serrato based on alleged misconduct. However, this request would significantly enlarge the issues in the litigation beyond the core dispute between the actual parties. The underlying case involves renewal of a domestic violence restraining order, while Gingras seeks to litigate entirely separate issues regarding attorney conduct, sanctions, and discipline referrals. Allowing such intervention would set a troublesome precedent where any non-party attorney who feels personally aggrieved by something in a case could intervene to litigate side issues and attacking opposing counsel. This is not what the Code of Civil Procedure, Section 387, contemplates. Gingras has no standing to intervene in this case. He is not a party to the Owens v. Maricini matter, and as of August 25th, 2025, he was no longer counsel of record for either side. Yet he seeks to intervene in the action solely to pursue personal relief against opposing counsel. This is an improper use of the intervention mechanism. The dispute is strictly between Owens and Maricini. Whatever personal interest Gingras has, reputation, avoiding sanctions, etc., is collateral to the subject matter of the litigation. There was no need for Gingras to intervene in order to respond to the motion to disqualify. The motion could have addressed or withdrawn without granting Gingras' party status. Typically, when a motion to disqualify counsel is filed, the affected attorney may oppose the motion or submit a declaration without formally intervening as a party. The decision on disqualification focuses on what serves the best interest of justice in the case at hand, not on conferring rights upon the lawyers involved. Yeah, it's not about the lawyers, it's about the parties. Here, since Gingras has already ceased representing Owens, the disqualification issue was largely moot, or at least non-adversive, as Owens did not oppose removing Gingras. In these circumstances, Gingras' intervention serves no legitimate purpose other than to pursue his sanctions campaign. Yeah, just so he can say, see, I got you. The court should deny intervention and require that any genuine issues regarding attorney conduct be handled within the existing party framework or referred to the appropriate disciplinary authorities separately. Gingras' grievances do not warrant enlarging this case beyond its core dispute. Exactly. The judge, for his own sake, should disqualify Gingras, tell him, you're a witness, that is it. I don't want to hear another dang thing you have to say until that point. Because we know how he likes to just spit things out and cause more things to go on in cases, cost the opposing party more money because they have to continue to answer these stupid filings that he does. California law provides no authority to strike a motion to disqualify. Rule 3.1322 does not apply to motions. Gingras seeks to strike the motion to disqualify pursuant to California Rules of Court, Rule 3.1322, under California law, or 1322, whatever, however you want to say it. Motions to strike are limited to pleadings, not to other types of motions filed in litigation. Any party may serve and file a notice of motion to strike the whole or any part of the pleading within the time allowed to respond to the pleading. 435. Notice of motion to strike complaint or pleading, extension of time to answer. The statutory framework specifically references striking the answer to the complaint or a portion thereof, California Code of Civil Procedure 435. Serrato's motion to disqualify was not a pleading, such as a complaint or answer, but rather a duly noticed request for an order in an ongoing case. There is no rule or statute that authorizes one motion to be summarily stricken by a counter motion simply because the opposing attorney dislikes its context or content. The disqualification motion was procedurally proper as a noticed motion seeking judicial relief rather than a sham pleading subject to being struck. A. The proper reason or response to disqualify motion in opposition, not striking. If Gingras believed the disqualification motion lacked merit, the appropriate course was to file in opposition and let the court deny the motion on its merits. Correct. Say why you don't think it's proper. Make your arguments, but you don't get to just come in here and do all this nonsense. California's procedural framework provides clear mechanisms for responding to motions through opposition briefs and oral argument, not through striking. Gingras chose to escalate with a punitive strike demand, which finds no support in California law. B. The disqualification motion addressed legitimate legal issues. Substantively, there is nothing irrelevant or improper about the content of the disqualification motion that would warrant striking it. The motion raised serious and valid concerns under well-established ethic rules. California courts have inherent authority under Code of Civil Procedure, Section 128, Subdivision A5, to control the conduct of ministerial officers and all other persons connected with judicial proceedings. Trial courts are empowered to disqualify counsel through this inherent power to control the conduct of ministerial officers in furtherance of justice. The determination of a motion to disqualify counsel requires balancing the interests between a client's right to counsel of their choice and the need to maintain ethical standards of professional responsibility. The paramount concern must be to preserve public trust in the scrupulous administration of justice and the integrity of the bar, as seen in these cases. This disqualification motion detailed legitimate concerns, including Gingras' role as a key witness regarding material events and potential conflicts of interest. It is indisputable that Gingras is a key witness regarding the June 2024 incident. Invoking the advocate witness rule, which generally bars an attorney from acting as trial counsel if he is likely to testify on a material matter. California courts have repeatedly affirmed that they have discretion to disqualify an attorney in such situations to avoid prejudice and protect the integrity of the proceedings. Gingras indicated that he wouldn't continue as counsel does not render the motion improper. If anything, it confirms the motion's point. Gingras was bound to become inflamed at Maricini's characterization of the evidence, and the risk in not filing this motion to disqualify was Gingras entering at the 11th hour to disrupt proceedings. His sensitivities are on full display in his moving papers. Exactly. Because somebody says something mean to Jingy and hurts his fifis, he has to go rage write about it. Rage writing is what he does. Serrato's filing simply ensured that Gingras' withdrawal was made official under a cloud of conflict so that he could not re-enter or influence the trial on behalf of Owens. This was a prudent step given the stakes. Basically, Judge, do you see why I wanted him disqualified? because this is the shit that he does. It actually gives more credibility and credence to Maricini and Omar's filings to have him disqualified and off this case, except for as a witness. In sum, there is nothing to strike. The disqualification motion was proper filing, addressing matters within the court's purview. It should simply be heard on its merits if it has not been mooted by events. Gingras Rule 3.1322, Gambit is a misuse of procedural rules. This court should deny this motion to strike. 3. Sanctions under California Civil Procedure 128.5 or unwarranted and unjustified. Gingras' centerpiece request to sanction counsel under CCP 128.5 is utterly without merit. 128.5 allows a court to award attorney's fees or expenses against an attorney who engages in bad faith tactics that are frivolous or solely intended to harass, which they're not. They are intended to get you off this fucking case because you don't know how to mind your business. The statute is to be applied sparingly, and it carries a safe harbor provision similar to CCP 128.7 and FRCP Rule 11, requiring the moving party to give notice and an opportunity to correct any alleged improper filings. Mr. Gingras' bid for sanction fails on both substantive and procedural grounds. You're all about giving notice, proper notice, Gingras. But you didn't do that. We thought you were an expert on giving proper notice and following procedural rules, and you hate it when people don't. You're such a lying hypocrite. Gingras promised false statements to the court. They do not exist, so he provided them himself. Oh, I like that. There were no lies told in Omar's writing, so Gingras made up some lies himself. Gingras' motion hinges on the accusation that Serrato lied to the court in the disqualification motion. The supposed lies boil down to 3 statements in Mr. Serrato's filings, as identified by Mr. Gingras. 1, that Gingras continues to represent Ms. Owens in this case. 2, that Gingras has a personal conflict of interest that materially limits his ability to represent petitioner due to pending state bar proceedings. 3, that allowing Gingras to continue as counsel would prejudice respondents' right and undermine the integrity of the proceedings. The first alleged representation was never made. This allegation from Gingras is as a blatant lie to the court. The motion stated specifically, David Gingras has since indicated to counsel, Omar Serrato, both verbally and in writing, that he does not intend to represent Laura Owens in these proceedings. And then he cites to where it is in the motion. Serrato was forthcoming about this conversation. If the motion nonetheless referenced allowing Gingras to continue as counsel, it would be after the disclosure of Gingras' intent and completely moot unless Gingras' attempt to continue as Owens' counsel. Gingras was counsel at the August 15th hearing and had not filed any withdrawal. Serrato never received notice of limited scope representation, but a 66-minute phone call was had where Gingras discussed continuing the October hearing for months to allow time to litigate. He spoke as a man who intended to represent Laura Owens, After the motion was drafted to disqualify Gingras, he then stated his intention not to represent Owens. Yeah, he wants to drag this case out, which you shouldn't want to do if Owens needs this protection order. If it's the only thing that's keeping her safe from Maricini, why do you want to drag out this litigation? Because you need months to litigate. You don't. You should have all the facts that Omar has. Because guess what, David? You actually have been on this file and case longer than Omar has even known about this case and all of Laura Owens' things. So don't feed bullshit like you need all this time to prepare when Omar has learned all this and done all this stuff in less time than you have. Gingras just wants to make a mockery of the judicial system. Okay. Serrato's phrasing does not intend to represent was a fair description of the situation. It left open the possibility that intentions might change or need to be formalized by court order. There was nothing malicious or deceptive here. In fact, Gingras' own declaration reveals the real disagreement. He wishes Serrato had worded it as no longer represents instead of does not intend to represent. Quibbling over verb tenses is not grounds for sanctions. This substance was conveyed to the court that Gingras was stepping aside, which is true. There was no false statement of material fact. The second allegation. Everything Serrato stated about conflict was factually supported. Gingras is the subject of a pending state bar disciplinary proceeding arising out of his conduct toward the respondent in this case. That is true. Yes, it is. And was supported by evidence. Gingras does not deny the disciplinary case exists or that it involves the June 2024 incident with Mr. Maricini, which is what he should do if he's going to represent those statements as lies. Least he himself materially misrepresents material facts to this court. Moreover, Gingras has stated that he intends to use this case to elicit testimony from Maricini that will aid in his defense in the bar proceeding. This statement is supported by Serrato's declaration and the declaration of Rachel Juarez, who was a percipient witness to the phone call referenced by Gingras. Gingras has never refuted that he made such statements. Indeed, it aligns with common sense that he would want to clear his name by extracting favorable testimony. These facts lead to straightforward conclusions. Gingras has a personal stake in this case, defending himself from discipline that could conflict with Owen's interests. Once again, Omar is doing more to actually protect Owens and her interests than Gingras is. But Owens just thinks that everybody is in a cult and Gingras is the one that should be trusted. No, it's not how it should be. For example, Gingras might conduct the DVRO trial or advise Owens in a way designed to justify his past actions rather than solely focusing on Miss Owens' current protection needs. This is a classic Rule 1.7 concurrent conflict scenario. Whether Gingras agrees that his material limits his representation is irrelevant. If he disagreed, he could have represented Owens and opposed the motion to disqualify. It is a reasonable assessment of risk, not a knowingly false factual assertion. Whatever the characterization, when we are arguing the interpretation of the facts, there is no lie. Third allegation. This statement is plainly an expression of legal opinion or argument, not an objectively verifiable fact that can be true or false. Serrato asserted that if Mr. Gingras were allowed to continue as counsel despite the conflict and witness issues, respondents' rights would be prejudiced and the proceedings' integrity would be undermined. Yeah, it is. It does not it does not protect Owen's rights. Gingras likes to make things about himself. Gingras bizarrely calls this a lie. This statement is plainly an expression of legal opinion or argument, not an objectively verifiable fact that can be true or false. Serrato genuinely believed and still believes that this is true. There is a solid foundation for this opinion. An advocate-witness situation inherently threatens the fairness of a trial as recognized by California case law. Likewise, a lawyer with a personal agenda could skew the presentation of the evidence in ways that harm the opposing party. One may disagree about the degree of prejudice, but treating this as a knowing falsehood is absurd. It's advocacy. Zealous advocacy for Mike Maricini is what Omar's job is right now. Importantly, the court is fully capable of judging for itself whether such prejudice would exist. Serrato wasn't hiding anything that would prevent the court from making an informed decision. No sanctionable misconduct can be predicated on this kind of statement. Serrato did not violate Rule 3.3A1, candor to the tribunal. He did not knowingly make a false statement of fact or law. He presented facts supported by evidence and arguments supported by law. Gingras did something else. Yes, we know, and the appeals court even told Gingras, your filings are not based in fact or law. He's been told that multiple times. And Omar is saying it here again. My filing, my request to the judge was based in fact and law. Gingras did something entirely different. He was writing a blog post basically and submitting it to the court. Gingras' own filing confirms the four facts. He appeared as counsel on August 15th, withdrew, and had a personal entanglement with his case. Far from misleading the court, Serrato equipped the court with relevant information, even quoting Gingras' intent to withdraw. Gingras appears to be satisfying an ability to avoid involvement in this case. If Gingras felt a nuance needed clarification, that could have been handled through a straightforward opposition or a simple notice to the court that he was no longer representing Miss Owens. Instead, he chose scorched earth accusations. Well, that's what he does. He has no middle ground. 0 to 100. The court should firmly reject the notion that any false statement occurred here and consider whether or not Gingras himself has ironically misrepresented material facts to this court. Agreed. B. The disqualification motion was neither frivolous nor filed to harass. But okay, before we get into that, like Omar was saying up here as well, is Omar said, here are the things that we think should disqualify David Gingras. Will you disqualify him, Judge? Basically, that's what that motion was. And the judge, knowing the laws and the facts that are presented, can say, okay, I agree he should be disqualified. Or the judge could have said, I don't think it's enough to disqualify him. Omar was just asking and saying, these are the reasons we think this is a good scenario for this to happen. The judge could either agree with it or not agree with it. Omar didn't have the power. He just asked. And what is the harm in asking? There is no harm. Just ask the question. All right, so now we're getting in. By any objective measure, Serrato's motion to disqualify was supported by ample factual and legal basis. It is therefore not frivolous, i.e., totally devoid of merit, nor was it filed for the sole purpose of harassing Gingras. Serrato articulated concrete conflicts of interest and cited on-point case law in his motion. This easily clears the low bar of any reasonable basis, needing to avoid the frivolous finding. It is worth highlighting the timeline. Mr. Serrato filed the motion promptly after the August 15th hearing, in preparation for a trial that was fast approaching. This time served to resolve counsel issues before trial, not out of delay or malice. Yeah, because you don't want to get to the day of trial and find out that Gingras went back on his word and he actually is there to represent her. And then Omar has to try to get him disqualified on the day that they're trying to have these evidentiary hearings. That's a whole lot of stuff that the judge was not prepared to deal with on his docket that day and can push his other cases or her other cases behind. And judges do not like surprises. Owens was expected not to oppose the motion, which undercuts any claim that it was meant to harass. The motion targeted Gingras's participation. Far from being vexatious, the motion to disqualify aimed to ensure a fair and orderly proceeding. It sought to prevent prejudice to respondent and protect court's process in line with the attorney's duties. More importantly, it foresaw the scenario where Gingras, after reading Maricini's characterization of facts that necessarily opposed Gingras's sworn declaration, would be triggered enough to attempt to re-enter proceedings as counsel for Owens. Gingras's intervention confirms the risk we flagged. It is a backdoor merits brief and a vehicle to re-enter as a de facto counsel. The disqualification motion anticipated exactly what has occurred now. After reading Respondent Maricini's statements of facts that necessarily contradict Gingras's sworn narrative, Gingras was triggered to reinsert himself into the case. Unable and ethically barred to cure that problem as petitioner's trial advocate, he instead styled himself as an intervener and lodged a motion that purports to police material misrepresentations, quote unquote. But in substance, rehashes and advocates the merits of the DVRO renewal and attempts to rehabilitate his own declaration. Yeah, he wants to rehabilitate himself. That's it. Which, sir, you're going to need to go to rehab to rehabilitate your image and your life. That rehabilitation comes from working on yourself, not this bullshit. Your public image isn't getting any better. That is precisely the scenario Rule 3.7 is designed to prevent: a lawyer witness trying to argue the case from counsel table and the witness stand at the same time, hereby converting a sanction/intervention filing into a surrogate trial brief. Gingras says his motion is about candor to the tribunal. The paperwork says otherwise. Yeah, because you know what the candor to the court filing is? It's a candor to the court filing. Just like Owen's former attorney, Keith, filed when he needed to have candor to the court. He was no longer representing, but he's like, hey, just to let you know, you can just take judicial notice and see this. I'm not trying to intervene. I'm just letting you know this. That is all. He could have done that, but he didn't. Most of his pages are spent recasting the June 10th, 2024 incident and other DVRO facts, previewing his testimony, attacking respondents' credibility, and defending his own conduct, subject he already sworn to in his declaration. This is not misrepresentation policing. It is merit advocacy by a necessary witness, and it's exactly why respondent moved to disqualify. Once Gingras' narrative is disrupted, he cannot resist litigating himself, either by trying to return as Owen's advocate or as here by using an intervention vehicle to function as an advocate in all but named. The result of Gingras' filing this motion to intervene are the following: abuse of procedure and court processes. Intervention and sanctions are not licensed to file a shadow merits brief. They are a narrow tool to address threshold party status or truly sanctionable litigation conduct. When a non-party lawyer devotes the lion's share of his papers to fact-bound disputes underpinning the DVRO, arguments he wants the court to adopt as true, he is misusing procedure to litigate issues he should address only as a witness under oath, subject to cross-examination. Circumvention of Rule 3.7, Advocate Witness. The advocate witness prohibition does not evaporate because the lawyer changes captions from counsel for petitioner to intervener. If the context of the filing is factual advocacy or on contested events for which the lawyer is a precipient witness, the prejudice and confusion Rule 3.7 seeks to avoid are the same. The court should not permit Mr. Gingras to do indirectly by intervention and sanctions that he cannot ethically do directly at trial. Conflicts and credibility become the sideshow. Gingras is always the sideshow. Allowing a non-party lawyer to use motion practice to defend his own credibility and attack respondent's version drags the court into collateral trial about the lawyer, not the parties. This is exactly what respondent warned would happen. It burdens the court, distracts from the merits, and forces respondent to litigate against opposing counsel as a fact advocate rather than confining Mr. Gingras to his proper role as a witness. Gingras' filings do not remedy any supposed misrepresentations. They confirm the need for disqualification. They are a merits-driven attempt to re-enter the fray and shape the factual recording through attorney argument instead of admissible testimony. The court should deny leave to intervene or strictly cabin any leave to the threshold non-merits issue, disregard factual advocacy in the intervention sanctions briefing as improper, and set the matter on a clean track where Mr. Gingras appears only as a witness and petitioner proceeds with conflict-free counsel. And that might just be herself because she doesn't usually get along with counsel. This is a 1 in a million time that she found somebody that's just as unhinged as she is. Gingras' characterization of the disqualification motion as having no purpose other than to harass is unsustainable. His briefing maligns Serrato's motives, claiming a personal obsession and vendetta. But the record tells a different story. Serrato's actions were precipitated by Mr. Gingras' own extraordinary conduct and the ensuing ethical entanglements. See footnote 1. Over the last 18 months, Gingras' actions in this matter have demonstrated a pattern of erratic and unpredictable behavior. This is exemplified by a conference call involving Serrato, Rachel Juarez, and Gingras, during which Gingras exhibited difficulty maintaining focus, communicating at an unusual rapid rate, discussed personal grievances, and indicated that he required Maricini's testimony to support his defense in an ongoing Arizona State bar proceeding. Given the imminence of the trial and the uncertain prospect of Gingras attempting to resume representation at a late stage, these circumstances provided a concrete basis for the motion to disqualify him as counsel. So, sounds like he might have been drunk on this phone call. Or on something else. Who knows? Going back up, a lawyer who moves to disqualify opposing counsel due to a genuine conflict is doing his job, not engaging in harassment. Yeah, well, he aligns with Owens, who thinks that people reading court documents is harassing her. No, it's not. To hold otherwise would chill attorneys from raising legitimate ethic issues for fear of personal sanctions. Gingras' accusations regarding YouTube videos and rhetoric are irrelevant and overblown. Gingras' level of extraordinary allegations that Serrato threatened Owens and her now former counsel with physical violence in a YouTube videos, that is not mere rhetorical flourish. It is an accusation that an officer of the court made criminal threats. If true, it would be disqualifying, but it is not true. Number one, the record is empty of any threats. The videos Gingras cites are still publicly accessible, and complete transcripts are readily available, if you so need those, Judge. They contain no threats of violence towards anyone, neither Owens nor Gingras, nor does any video in Serrato's category or catalog. What Gingras points to boils down to a single colloquial phrase, want the smoke, and B, a satirical, obviously doctored thumbnail image used for comedic effect. In context, do you want the smoke is a common slang for do you want the conflict? Do you want the challenge? Typically understood as figurative and often verbal conflict, it is not a literal promise of bodily harm. No, like people will say it like jokingly, oh, you don't want this smoke. And it also goes with his Conor McGregor reference, which I don't think Omar puts anything about Conor McGregor in here, but I mean, it goes with that. It's a play on fighting words. It's not harm. 2, California law requires a true threat, not rhetoric or hyperbole. A punishable or sanctionable threat requires words that, in context and in light of the surrounding circumstances, convey a serious expression of intent to commit unlawful violence, and are made with a specific intent that they be taken as a threat. And they cite a case. Ambiguous or hyperbolic language, satire, and rhetorical bravado, particularly in public commentary about a matter of public interest, do not constitute a true threat. Here, the slang phrase and meme-style graphic fall squarely on the rhetorical side of that line. There is no direct statement of intent to inflict harm, no immediacy, no directive, no targeted menace, and no evidence anyone experienced the sustained fear. Penal Code 422 contemplates. On this record, the legal threshold for a true threat is not remotely met. 3. Context Gingras omits. The video predate Serrato's representation and were part of a public legal debate. Gingras also fails to tell the court that the cited videos were published before Serrato ever appeared as counsel in the case, and during a period when Gingras himself was producing content and engaging publicly about the same issues. Serrato was acting as a legal commentator in a widely followed public controversy, driven largely by Owens v. Eckerd saga. The two layers exchanged content critiquing each other's legal positions, including procedural/ethical issues. Serrato and Gingras exchanged content regarding a legal debate about Federal Rule 11 and its application to Arizona family law. At no time during the production of those videos has Gingras ever raised the idea that threats of violence were proffered. However, several members of the public who followed this case had commented that Gingras produced video content with firearms in the background that they perceive as threats to Serrato, and others who had fallen out of favor with Gingras for disagreeing with him. See footnote 2. It is observed that much of Gingras's online content, including social media posts and YouTube videos, is no longer publicly accessible. While the Arizona State Bar is conducting an ongoing investigation concerning his public conduct on these platforms, the reason for the removal of his content have not been expressly disclosed in the record before the court. Well, I think Florida has some answers for Gingras's fake hacking. All right. Irrelevance and prejudice, even if the court credited Gingras's spin. Even if the court were to accept Gingras's strained credulity, in my opinion, reading of slang and satire, none of the third-party YouTube ephemeria is relevant to the questions actually before the court. Look at Omar using big words. We might have a word of the day today. Learning a new word. Let's see. Ephemera. Things that exist or are used for or enjoyed for only a short time. Ephemera. So third-party YouTubers' ephemera is relevant to the questions actually before the court. Whether Serrato's filings were frivolous or in bad faith, or whether Gingras can ethically continue in a dual role, Evidentiary Code 350. Interjecting screenshots and internet slang only invites confusion and undue consumption of time, Evidence Code 352, and distracts from the merits. And to the extent Gingras is relying on third-party creators' commentary to bolster his narrative, that material is hearsay, often multiple hearsay, typically unauthenticated, and not attributable to respondents' counsel in any event. Gingras' theory that Mr. Serrato filed the motion to disqualify to create new YouTube content is unsupported and unreasonable. Serrato filed one motion on a serious issue and has not created any content related to Owens or Gingras since entering this case in August of 2025. He cannot control the content practices of others creators who continue to cover this case because of the public interest in Owens' conduct. Correct. There is nothing there. E. Gingras' online war with public who follows this case, threatened lawsuits, retaliatory takedowns, and direct attacks on respondents' counsel. Striking portion of Gingras' filing is devoted to YouTube videos and commentary created by people other than Respondents' Counsel, complete with screenshots and links, including a court of random opinion video and other channels content that Mr. Serrato did not produce and cannot control. Gingras' declaration likewise parades thumbnails and insults he attributes to the Tilted Lawyer channel and friends, again conflating independent creators' speech with litigation conduct in this case. This is telling his true dispute is with those third-party commentators, not with any action or tactic by Serrato cognizable under the sanctioned statute. That matters for at least 5 independent reasons. Let's see what those reasons are. First, the fact that Omar even has to spend time opposing this bullshit that he could have been using to do things for Maricini is ridiculous. It's a waste of time. It's a waste of money. All right, so we've got our reasons. Number 1, sanctions must target litigation conduct. Code of Civil Procedure 128.5 and 128.7 reads actions or tactics of a party and a party's attorney in the litigation. Third-party YouTube uploads are not respondents, actions, or tactics, and Serrato has no legal ability to control what unaffiliated creators publish. Sanctions cannot be opposed to punish a lawyer for someone else's out-of-court speech. And then he cites to where it is. Irrelevance and prejudice, Evidence Code 350 and 352. Whether other creators posted harsh commentary about Mr. Gingras is irrelevant to A, the merits of the DVRO renewal, B, the Rule 1.7 conflict, C, the Rule 3.7 advocate witness problem, or D, any allegation that Serrato filed a frivolous motion. Injecting third-party videos invites many trials on YouTube gossip and creates undue prejudice, confusion, and consumption of time. Yes, you're wasting Omar's time. Hearsay, lack of foundation, and authentication. Screenshots and clips of what others said online are hearsay, often multiple hearsay, if offered for their truth. They are also frequently unauthenticated and lack proper foundation of personal knowledge. Yes, because we're giving our opinions. We are reacting to the filings or the court hearings, videos, and things like that. That's it. Mr. Gingras offers them to paint a narrative about respondents' camp, but that proves nothing about respondents' counsel litigation conduct. Evidence Code 1200, 702, and 1401. 4. No duty and no power to police independent speakers. Yeah, even though he is a First Amendment parent lover, he's not. California law imposes no duty on counsel to moderate, retract, or correct independent third-party commentary. To the contrary, California courts recognize that the state court remedies cannot be used to command the removal of third-party online content, even when alleged to be fake or false, not fake, underscoring that courts are not content moderation boards. Hassel versus Bird. 5. Safe harbor theory collapses when the harm is a third-party speech. Gingras tries to dodge the 128.5 and 128.7 safe harbor by claiming incurable reputational harm from online republication of his accusations. But those republications are third-party acts he deliberately put at issue by submitting a motion laden with YouTube exhibits. Safe harbor is not excused because unrelated speakers talk about a filed motion on their channels. Yeah, and it's not prejudicing Laura because The judge is not out here watching all of our YouTube stuff. Further, he attempted to create a media storm by previewing his motion for sanctions, teasing its filing, commenting on it publicly, and blogging out about it for days after the filing, perhaps as a gauge to see how his arguments with the public would be perceived. He wanted the attention. He invited the attention and was anxious to see the public's react to his filing. Exhibit B, Gingras' blog. Now, I don't have the exhibits. If somebody has the exhibits, let me know, unless it's with the Rachel Juarez declaration, which we'll go over in a separate video. Okay. At bottom, this court is not the forum to settle Gingras' dispute with YouTubers. His motion lays that bare. Rather than confine himself to alleged misstatements in a court filing, which he never identifies with specificity, he spends page after page litigating the internet, a campaign that is neither relevant nor cognizable under the sanctions rules. The court should sustain respondents' evidentiary objections, relevance 350, undue prejudice / consumption of time 352, hearsay 1200, lack of foundation in personal knowledge 702, lack of authenticity 1401. Disregard the YouTube-based material and arguments and deny the request for sanctions and strike relief. To the extent these third-party exhibits were offered as a proxy to re-argue the merits of the DVRO or to rehabilitate Mr. Gingras' own declaration, that only confirms why he cannot ethically continue in a dual role. He is attempting to prosecute a broad public relations grievance through this case. Yeah. As further evidence of this deep obsession with third-party content creators, the court should be aware that he has a long history of threatening and publicly feuding with content creators who don't agree with him. Content creator Dave Neal publicly documented receiving a threatening email from Mr. Gingras and was tied to Neal's critical coverage. Video segments showing the email and summarizing the threat. Additionally, Neal has separately covered Gingras' repeated defamation and threat rhetoric towards creators who have discussed this case. Exhibit C is screenshots of Dave Neal video regarding Gingras' harassment. Investigate journalist Megan Fox similarly reports that Mr. Gingras, with co-counsel, demanded that coverage stop immediately or change to favor their clients. And she has repeatedly noted Gingras' defamation lawsuit threats direct at independent reporters. Exhibit D, Megan Fox tweet regarding Gingras' harassment. Beyond threats, Gingras has weaponized DMCA takedowns on his own law firm blog. He boasts that YouTube approved his copyright strike against a small critic, Loud Little Ducky, and celebrates the takedown. Justice for Dingus, expressly linking his strike to the creator's criticism of respondents' disqualification motion. Exhibit E, Loud Little Ducky blogs. The same blog series is used to attack respondents' counsel personally. Gingras accuses Omar of having straight up lied to the court, announcing he moved to intervene solely to seek sanctions and a state bar referral against Serrato, and unequivocally defamatory statements that was published for anyone who follows the case to see. Exhibit E. Yeah, because in his blog post where he attacks me, he went after me and Omar in that one blog post. These episodes are not isolated. They form a pattern in which Mr. Gingras threatens legal action, bar complaints, copyright takedowns, demand letter notices against content creators who critique or report on the Owens litigation. The timing, language, and frequency of these threats suggests they are being used to suppress public criticism and defend Gingras's personal reputation. The pattern of behavior has predictably spilled into the pleadings in Owen's DVR renewal case. This motion should be Exhibit A, demonstrating Gingras's involvement in the case is not only as counsel for petitioner, but also as an actor seeking to control public disclosure, a role incompatible with fair impartial representation under Rules 1.7 and 3.7. Yeah, it's all about Gingras. It's not about Owens. I mean, to Owens, it's about Owens, but it's a real problem when you have two people that want to be the main characters. Like, somebody's got to be the supporting role, and both of them want to be the star. F. Gingras did not adhere to the safe harbor procedure with no valid exception excuses this failure. California Code of Civil Procedure Section 128.5 incorporates safe harbor provisions that mirror those found in Section 128.7. Under these provisions, a motion for sanctions shall not be filed with or presented to the court unless within 21 days after service of the motion or any other period as the court may prescribe. The challenged paper, claim, defense contention, allegations, or denial is not withdrawn or appropriately corrected. California Code of Civil Procedure 128.7. California courts have consistently held that the strict compliance with the safe harbor provisions of Code Civil Procedure 128.5 and 128.7 for sanctions motions is required, and failure to comply with the safe harbor provisions precludes an award of sanctions. And he cites a case. The safe harbor provision establishes a two-step process with a safe harbor waiting period. The moving party is to serve the sanction motion on the offending party, but cannot file it with or present it to the court unless within 21 days after service of the motion or any other period as the court may prescribe, the challenged paper claim, defense, contention, allegation, or denial is not withdrawn or appropriately corrected. He cites a case that says this procedural requirement is mandatory, and the full 21 days must provide absent a court order shortening that time if sanctions are to be awarded. That's why we know Gingras is not serious. He was just doing this to gain attention. Because he would have followed the procedures if he really wanted Omar to be sanctioned. That or he was too drunk and forgot he needed to do that. Gingras admittedly failed to comply with the safe harbor provisions. Gingras explicitly acknowledges that he did not comply with the safe harbor requirement in his motion. Gingras states that he filed motion without prior warning and emphasizes this fact. This admission alone is sufficient to mandate denial of his sanctions motion under established California law. The purpose of the safe harbor provision is remedial, not punitive, and it is intended to foster compliance and to conserve judicial resources, otherwise spent adjudicating sanctions motion by affording a prescribed period of time during which a party may correct or withdraw a frivolous or improper pleading, or motion without any penalty. Something he knows about and argues about all the time. It's his biggest thing. Except for, in this case, there was nothing. And everything. Whereas when Gingras read the Rule 26 argument in the Eckerd case, Woodnick was like, okay, I'll withdraw. Whether it was, you're right, I didn't do this, but it wasn't about the 21 safe harbor. It was about a separate filing and then doing it, things like that. But it was withdrawn. So the Rule 26 thing was mute. Here, there was no prior warning. I just want you to do this, Judge. Don't even give him a chance. But give Laura chances, but not anybody else. Bypassing this process entirely, Gingras deprived both the court and opposing counsel of the opportunity to resolve the matter without litigation. Gingras' exception arguments do not apply. Recognizing his procedural failure, Gingras attempts to invoke a narrow exception to the safe harbor requirement, arguing that the harm was irreparable and could not be mitigated by withdrawal. However, this exception applies only in extremely limited circumstances where the very act of the filing or the manner of filing causes a harm that cannot be undone. The cases Gingras cites to support his exception argument are distinguishable. In the marriage one, footnote 3, an attorney's bad faith conduct was sufficient to support the imposition of sanctions under the code because the attorney not only failed to appear because of the trial conflict, but also misrepresented readiness for trial and failed to correct that misrepresentation, and the record could support a finding of subjective bad faith. Okay. The exception applied because an attorney misled the court and about being ready for trial, causing the court and parties to waste a trial date and incurred harm that withdrawal of the statements wouldn't fix. In Shinnefield 4, it was a child custody dispute. The husband's attorney was properly sanctioned for unwarranted disclosure of confidential custody evaluation because the husband's declaration, which the attorney filed, quoted a psychological evaluation from the wife's previous marital dissolution. Attorneys can make unwarranted disclosures for the purposes of Family Code 3111. All right. Going back up here, says an attorney publicly disclosed confidential material in a violation of the statute. Once out, the secret was out. So no retraction could undo the breach. Yeah. That's not what happened here. There's nothing that Omar put out that ruins your reputation because everything is already known. And he's not wrong. I mean, you've basically proven Omar right. You are exhibit A to why you should be disqualified to the judge. 3. The alleged harm does not justify bypassing the safe harbor provision. Gingras claimed harm, including the reputational damage from YouTube videos discussing the disqualification motion, does not meet the standard for the safe harbor exception. Yeah. Because that's why he really copyright struck me. It wasn't about the picture. It's because he doesn't like his reputation to be harmed. Reputational damage, reputational harm to an attorney is not the concern of CCP 128.5. The concern is abuse of the court process. The alleged harm is essentially personal embarrassment, which does not warrant dispensing with a statutory prerequisite. Furthermore, the pleading in this case are open to the public. Serrato did not publish any content related to any pleadings in this case, and Serrato has no ability to prevent other content creators from commenting publicly. Gingras' anger is misplaced. Hey, don't tell him to come back over here, Omar. Omar, I will bring the smoke and the fire. Don't Get this ducky's wings a flapping. Don't tell him to come put his anger over here. I will forgive you because you're trying to do this in court. But, sir, I will smack you with my wing. 4. The extreme requests for disciplinary referral should be rejected. Gingras asked the court not only to punish Mr. Serrato with sanctions, but to make formal findings of ethical violations. Rule 3.1, 3.3, 4.1, and 8.4, and refer Mr. Serrato to the State Bar for investigation. That's what he wants. It appears designed more to generate flashy talking points for his blog or headline than to address any genuine threats to the profession. The court should decline this invitation to overstep. Rule 3.1 is the frivolous action. He says that Serrato did not pursue, or Gingras wanted to say this was a frivolous action and broke Rule 3.1. Serrato says he did not pursue a frivolous position. The motion disqualified has substantial merit and was rooted in legitimate concerns. It was not filed to harass or maliciously injure Mr. Gingras, but to protect respondents' rights. Rule 3.3, candor to the tribunal. Gingras said that Omar broke that rule. Serrato did not knowingly make false statements of fact or law to the court. All material facts were fairly disclosed, including Mr. Gingras' intent not to continue, and the legal arguments were grounded in existing law. There is no deception to the court. Mr. Gingras' disagreement with phrasing does not equal a Rule 3.3 violation. The next rule that he said that Omar broke was Rule 4.1, truthfulness in statements to others. And Omar says, this rule concerns false statements of material fact or law to third parties. Example, in negotiations. Gingras has pointed to no specific communication to a third party in which Serrato lied. Everything in the motion to disqualify Gingras was based on law and fact, derived from the sworn declarations of David Gingras and other exhibits used in the motion. That Mr. Gingras tried to get Mr. Maricini arrested, and that he faces bar complaints, etc. It may be unflattering, but the truth is an absolute defense, both in defamation law and certainly against a Rule 4.1 accusation. And then the next one that he says that Omar disobeyed was misconduct. And Omar says this catch-all rule, specifically 8.4c, cited by Gingras, prohibits conduct involving dishonesty, fraud, deceit, or recklessness, or intentional misrepresentations, as well as conduct prejudicial to the administrator of justice. There is no evidence of fraud or deceit by Serrato. Filing a motion that Gingras doesn't like is not conduct that prejudices the administration of justice. Gingras' attempt to equate vigorous representation with ethical misconduct is unsupported. You tell him, Omar. Put him on tilt, Omar. If Gingras honestly believed Serrato's behavior in this case violated professional rules, he is free to report to the California State Bar. Exactly. This is not the proper place to do this, Gingras. The bar then evaluate the matter independent of the proceedings. Dragging the court into making a finding and referral is unnecessary. Yeah, you can just go right to the bar yourself. Courts typically reserve disciplinary referrals for clear-cut, egregious misconduct that a judge personally witnesses. Example, an attorney lying in open court, tampering with evidence, etc. There is no incontrovertible act of dishonesty or obstruction before the court that would compel disciplinary action. The court should decline Gingras' request emphatically. Mr. Gingras' motions have already created a sideshow. The court can close the curtain on it by denying these extreme measures. Conclusion. Gingras' motions are unnecessary and inflammatory tangent to the real issues in this case. Gingras chose to interject himself into this proceeding, and when met with rightful resistance through a well-grounded disqualification motion, he retaliated with personal attacks and meritless requests. This is where Gingras doth protest too much. Because Gingras says that everybody is retaliating against him. Mike is retaliating against Owens. Mike is retaliating against Gingras. When Mike is not the one looking at revenge. That is Gingras thinking that because that's what he does, that what must be what Mike is doing when it's not. Projecting. The court should not allow this approach. Serrato's conduct did not violate any laws or rules to warrant sanctions or disciplinary actions. By contrast, Gingras' filings exemplify the scorched earth tactics that waste judicial resources and turn a domestic violence case into a personal grudge match. Yeah. It's not about you. Respondent and his counsel urge this court to bring the focus back to the parties' dispute and put a stop to the peripheral attorney feud. Denying Mr. Gingras' motions will send the message clearly. We ask the court to do so and allowed Owens and Maricini matter to proceed on course, free from further distractions. Dated September 23rd, 2025. Respectfully submitted by Omar, attorney for Mike Maricini. Good on Omar for just saying, hey, can we knock this nonsense off and just get back to this case? Because that's what we're trying to do here. We're trying to resolve this legal matter. And what Omar didn't do is say, you know what? I think instead of me being reported to the state bar judge, I think he should be referred to the state bar. I think that Gingras should have sanctions. Omar could have put that in there. But Omar said, hey, knock this shit off. Let's get this case resolved. This is what we're here for. This is what we need to focus on. Forget all this other nonsense outside of it. That is him protecting his client and Omar doing what is best for Maricini. Not Omar trying to get at and do things to Gingras to retaliate against him for what Gingras, said about his, that was not great for Omar's reputation. But Omar didn't retaliate. I mean, it shows who's a professional and who's a clown show. That's going to be it for me on this document. We will have more videos coming out, body cam footage and Rachel Juarez's declaration, and hopefully the exhibits that are supposed to be attached to this motion, but I do not have at the moment. So if anybody has those, let me have them. You can send them to me, loudlittleducky@gmail.com.